Now, here are your hosts for today's show.
Good evening. My name is Matthew Noyes, and it is Tuesday at 5 o'clock, and that means we are here for another edition of FLA Law on the radio. This is a live legal call-in talk show, and we are here to answer your legal questions. I am a partner at the law firm of Perenich, Caulfield, Avril Noyes, the oldest personal injury law firm in Tampa Bay. We've been serving the people of Tampa Bay since 1955. And I'm here to answer any questions that you may have regarding car accidents, workers' compensation, even Social Security disability. But I'm not here alone. I have my friend and my colleague, Bill Demas, here as well. Bill has been on the show once, I believe, before, and I'm so glad that you're back again. Bill, can you introduce yourself to our listeners, please?
Sure, Matt. Thank you for having me. My name is Bill Demas. I'm with the law firm of Herman & Wells in Pinellas Park, Florida. And I practice disability litigation with long-term disability and short-term disability, and also life insurance and accidental death and dismemberment, which is different than Social Security disability. So it's another level of disability that people have through insurance policies, either through work or privately.
Yes, and so if you have questions within the next hour about long-term disability or about short-term disability or other employment types of disability policies, Bill's your man. We refer our cases over to him whenever there's a question regarding the long-term or short-term disability. So how do you get to us? You can get to us several ways. You can call us live on the radio at 727-441-3000, and that gets you right onto the law line, and we'll be here to answer any questions that you have. If you don't want to hear yourself on the radio and you just want to send a question instead, we are also on the live feed at the firm's Facebook page. The firm is Perenich, Caulfield, Avril Noyes Injury Lawyers. And so you can jump on the live feed. You can see Bill, and you can see myself here in the studio. And you can type in your questions right there, and we'll be happy to address those. And thirdly, we are also live on our YouTube page, the Perenich, Caulfield, Avril Noyes YouTube page as well. And you can see us there as well. But if you have questions, this is the time to call. Oftentimes, near the end of the show, we have a lot of calls in and we can't take them all. And so it's always better to reach out early in the show so we can address your question. So give us a call at 727-441-3000. Now, Bill, you talked about long-term disability, and that's your area of specialty. Can you kind of explain what long-term disability is and how it's different than Social Security disability, and why is it important for individuals to have that?
Sure, I'll be happy to. So a lot of people call my office and say, I'm looking for a long-term disability, and they're really talking about Social Security disability. Long-term disability in that term is a disability insurance that comes from an insurance policy, either A, through work. You work at a firm and they offer it as a benefit that you can add, or they give it to you for free as a benefit, kind of like health insurance, or you buy it from the same gal or guy that you buy your car insurance for, and those are private policies. Long-term disability varies from Social Security disability because there are no set rules. And Social Security disability, as you know, because Matt does it and does a very good job at it, the government has set rules. This is what disability means. This is the federal law on disability, things like that. In long-term disability, it is literally your disability is what the policy that you bought says it is.
Oh, okay.
So that's like buying a new board game and trying to figure it out without the instructions.
Sure.
So the rules of the game are the policy. And so when everybody calls me up and says, oh, well, I'm disabled because of XYZ, I said, what does your policy say? Well, I don't know. Well, you can't win the game if you don't know the rules. I need the policy. So they're basically, the difference is policy driven and the government has no intervention.
And now also you said that you can get it through private insurance. You can buy it yourself, or you can go through your employer. Is there a difference in type of policies if it's employer provided or employer based?
Oh yeah. And let me tell you that we could have a whole show on this distinction, but we're not going to get into it. I'll just tell you quickly. When you have a policy through your employer, it's under a law called ERISA, and it's a federal law. And ERISA
I always cringe when I hear that.
Right. ERISA is the acronym for it. And it's basically born of a law that was put in effect to govern pensions and other things during the 70s, early 70s, when there was that hint of corruption going on. The government says, this is what we're going to do to monitor it. And then as employers started offering other benefits, health insurance, life insurance, disability insurance, Congress went, do we make a new law? No, let's throw it under ERISA. So as these things happen, they come under ERISA. Now, ERISA is a different animal, and there's not many of us in the state that do it. So you'll maybe find somebody that will do a private policy because the rules are different. With the ERISA, you're in federal court. There are strict discovery guidelines, meaning what the insurance company has to give you or not. There are tight timelines, and they look at it in a whole different way. It's not like what you see on Law and Order and things like that. It's literally a whole different set of rules that really favor insurance companies.
Sure.
Which makes it why there's not a lot of people on my side, because a lot of people don't want to engage in the fight. And it's super technical and super complicated, just like Matt saying he gets cringes upon it, because in law school you hear the word and you just cringe about it. Private policies are different. Private policies are what you buy from your insurance agent, which she sells you, he sells you. And those rules are more akin to your homeowner's policy, your motor vehicle accident policy, meaning that it follows those typical lines of you have to put the information in, then you can sue them, and then you can do discovery and get depositions, and you get a jury trial, and you get all those types of things. Now, the nuances of the policy, as you will know, there's a huge difference from doing Social Security disability and even private long-term disability, because, again, the rules are what the policy says.
Right.
And the proof is different. But the main difference between the policy you get through your work and the policy you get through your insurance agent are twofold. One, the price. The ones through your employer are much cheaper.
Oh, okay.
But you get what you pay for.
Oh, that makes sense.
In the one you get from your employer, you can't submit evidence after you file a lawsuit. You don't get a jury trial, and you get a federal judge who is appointed for life determining your case, usually on written submissions, which called a motion for summary judgment. A private policy, more expensive, but it has a guaranteed set benefit. And if they deny you, you have a right to file suit, do discovery, have a jury trial with juries of your peer, not a federal judge. And most likely those cases are usually kept in state court. So you have Pinellas County people instead of federal court, where you have
federal judge,
yeah.
And
then you have federal jury selection, which, as you know, Matt, federal jury selection is not like the jury selection that we do.
No.
A lot of federal judges don't let you question the witness. You submit questions, and then they question, not with the witness, the jurors. They question the jurors. So as an attorney, you don't even get you've done juries.
Right. You don't get to build a rapport.
Right.
You don't even get a sense of those people.
Right. As a trial attorney, Matt, what's probably the most important part of a jury trial?
I always say it's the jury selection. And cases are won or lost before the opening statement is made.
And in federal court, all you do is hand a judge a list and go, ask him right. I mean, you have nothing. So those are the main differences.
Yeah. Well, that makes sense. And so I would think, I know, unlike some attorneys that do handle long-term disability denials and short-term disability denials, you handle not just the private ones, but you also handle the employment ones or the ERISA ones as well.
Yeah, the ones that get through work, I handle both, and I will handle them from inception to the end of trial. And a lot of times people hire me when they're thinking about applying for for long-term disability. They'll hire me, and I'll actually file the application for them to make sure that things go smoothly in the beginning, especially in these employer plans where you don't get discovery. So if you don't do it in the appeal.
I was going to ask you about that, because we a while ago when we did Social Security disability, we would always before we would always have the applicant just fill out the application themselves.
Mhm.
What we realized it's probably better if we help out with the application process. And then that's what you do as well. In a lot of situations, you help them with the application.
Yeah, I always give them the option if they call me early. Listen, I can do the application for you, okay? And this is what and I'm always ethical and honest. This is what it financially looks like to you, okay? These are the benefits of doing it. These are the cons of doing it. And really the only con is that we may cost you a little more money.
Right.
But especially in these ERISA cases where people say, I'm going to handle it, the initial application, and then when I get denied, I'm going to appeal it myself. And then if I need to hire an attorney, I'll go. What they don't understand is they're treating me like a test pilot. I could be Chuck Yeager. If you build me a plane with no wings, I'm going to crash it.
No matter how good of a pilot you are.
Right. I'm going down.
Right.
So what they have to understand is when they do their initial application and they do the appeal, they are building the plane. Okay. Or if you want to go to, our military folks out there, they are packing the parachute. Right?
Okay. Yeah.
And what the old rule about the parachute packers is that the troopers that pack the parachutes every week or whatnot, every month, every week, I don't remember which one it is, the sergeant goes through and randomly pulls parachutes that they're packing and gives it to him and says, you're jumping on this chute. You're jumping on this chute.
I didn't know that.
Yeah. The reason being is that they don't know which one they're jumping on. So they always do a good job.
Right.
Okay.
No, that makes sense.
So again, and that's the story that I heard from my dad who was in the force. Is if it's not happening now, I apologize, guys, but that's what all those years ago, my dad's 87 told me that story. So it's one of those is that we're packing the parachute with the initial and the appeal. And if you don't do it right, you can't expect a soft landing.
Right. And you don't, if you it's like me trying to fix my air conditioning at home.
Right.
I can try to fix it myself and I can do this or do that, but eventually I'm going to have to call the AC guy.
Because you're going to do more harm than good.
I'm going to do more harm than good. It's going to cost me more because of what I tried to do myself. Right. And I think that's the same thing in the long-term and short-term disability route.
And you see it with the Social Security where these people come to you and they say, hey, I have a hearing. They've done all the appeals themselves. Right. And they say, I have a hearing in a month. And you said, well, what have you submitted? And they go, oh, nothing. Social Security was supposed to get my records. You're like,
yeah. Sorry. It's going to be hard to help you on that one.
Yeah,
that's for sure.
They probably didn't.
Right. Right. So, and I think that leads us to something good that I wanted to talk to you about in Social Security. The most important thing we need is documentations of the things that prevent them from being able to return to substantial gainful employment.
Right.
A doctor saying you're disabled doesn't do any good. You need to have the documentation. What type of documentation is needed in order to be successful in a long-term disability or short-term disability claim?
Well, that's a great question because, and I'm going to start it with this, and this is something that you will also agree with for your Social Security clients. I'm telling this to everybody out there. It is your job, folks, to get your medical records and confirm, usually through certified mail, that either Social Security or the insurance company got it. Because if you rely on them to get the records, or you rely on your doctor to fax them, they will never get there.
Right.
Matt can tell you probably 15 examples in the last 2 months of clients saying, but my doctor said they faxed it, or I saw my doctor fax it. Well, then you're trusting Social Security or the insurance company to say, yes, we got them, which I'm not saying they lie, but they never get them. So
they're there. They just don't know where they are.
Oh, yeah. Especially in Social Security, they go into the abyss, right?
Right.
Well, with a certified mail, if Social Security says we never got them, Matt turns around and says, that's funny because the Postmaster General of the United States says you got them on this date. And any Social Security judge and any federal judge will side with Matt or me with those green cards because you can't go against the Postmaster General. Right. They probably lost them. Right. So first of all, it's important that you send your medical records in yourself through a tracked means. In terms of important information, of course, it's your medical records. Okay. Medical records, folks, not medical summaries. I know Social Security hates them, and insurance company hates the medical summaries. What are medical summaries? Well, when you go on your patient portal and they go, download your medical records now, and the top of it says patient summary, that's a summary. That's not the medical records.
Right.
Matt, have you seen that too?
Yeah, I've seen that too often.
And the medical summaries are incomplete. They really are. They don't have
It's just an overview.
Right. It's an overview for you to sit there and go, oh, this is what my blood pressure was. Oh, this is what my weight was. I mean, it's not really going into the neurological findings and the things like that. So get your medical records, and you can get them for free or for under $10 with a law called High Tech. Is exactly how it's spelled, exactly as you sound. And you can go online and you can download a form that allows you to present that to your doctors in order for you to get your medical records. Now, what I said about medical records, always make sure they go to you. Don't put your insurance company down, because as soon as you put your insurance company down, the medical records company, the doctor doesn't have to honor that request. So have it sent to you, and then you send in. The other thing that is good for both Social Security and long-term disability is something we call a symptom journal. And that can be as simple as a composite notebook that we had, in school. A lot of the younger people have no idea what we're talking about, Matt. But
what's a spiral binder?
What's a spiral binder? Yeah. So have one of those. Now, technology allows you to get on your phone and download a symptom journal. My symptom journal, or my pain diary. There's a bunch of them on there, and they're awesome. You pull them up, and they will say what part of the body hurts, and they have a little diagram, and you press it. And if you're having headaches, where in the head, and you press it, and it goes, says it's in the back, and this and that, degrees and pain, and then it turns into a PDF with a chart and an explanation that you can print out and send to the doctor, send to Social Security. I have my clients do that, and the ones that have Social Security claims, I send it to the Social Security attorney, and you'll put it in, and it's no longer subjective complaints when they have contemporaneous. They have a log for 7 months of the same complaints, and once the doctor looks at it and says, "Yeah, I agree that these symptoms are consistent with what the findings are," how does somebody say that our clients are lying?
Right. No, right. I agree 100%. We do that in our auto accident cases as well. It's so important to it's document. And we as lawyers can only document so much.
Right.
It's really up to our clients to make sure that the doctors are documenting.
Right. And the last thing I want to say, which works in both our practices, Matt, is pictures. Now everybody has a professional camera in their pocket at all times.
Exactly, nowadays.
Okay? And we have a lot of clients that have conditions that cause other accidents. They have back pain that makes their leg go. They have a knee pain. They have drop foot, and they trip and they fall and they drop stuff. And I say, take a picture. If you fall and bang your foot or bang your knee or bang your head, I know it's embarrassing, but take a picture of the bruise, of the injury, the scratch, the lump. And your phone will date it, and then so you can go to the judge and go, "Your Honor, she's not lying about falling. Here are pictures of her falling," and I can send it to the insurance company. They can show it to their doctor. Another thing is, there's a lot of women out there that have these rheumatological conditions, whether it's lupus, whether it's fibromyalgia and things like that, and they flare and they spike. And one of the symptoms are fever. Sorry. And, well, how do you prove that you have intermittent fevers? Well, by feeling hot, turning on your video to record a video, put the thermometer in your mouth, take it out, and show them.
All right.
And then you can go to your doctor and say, "Look, no, I really did have a fever. Look, doc, this." And your doctor's going to say, reported problems, documented fevers, blah, blah, blah. And then when you go in front of the judge, you have a judge saying, "Well, it's just what she's saying." You go, "No, Your Honor, it's documented to the judge, and I can show you the videos if you want to see."
Right.
Here it is, date stamped.
Yeah, it's so important in all areas. In what we do, it's so important to have that documentation.
Well, with the car accidents cases too.
Right.
There's no reason why unless they're really, really injured. I mean, on the amount of people that, I've talked to with car accidents, and I said, "Well, did you take a picture of the scene?" No.
Yeah. No. Right. It's like, okay. So
Okay.
it is always educating. And now after a car accident, and after a disability, you're
Or
freaked out.
Yeah, and you're freaked out. But workers' compensation too.
Right.
I mean, listen, an employer, after somebody hurts themselves, can't say, hey, don't take a picture of
that area. Yeah.
or the fact that you're flat on your back and the shelf fell on you. I mean, if there is proof in our pocket that people just need to take out and click pictures, and it helps everybody, because how they remember it may not be how it was, but the picture never lies.
Right, that's for sure. I just remind all our listeners that you are listening to a live legal call-in talk show. That's Bill Dimas, and I am Matthew Noyes, and we are here to answer questions that you have. The law line number is 727-441-3000. Bill can talk about short-term, long-term ERISA and accidental death
and dismemberment
insurance coverages, and I'm here to talk about any auto accidents, car insurance, work injuries, or even Social Security disability. So this is the time to call now if you have a question, and it's 727-441-3000. And Bill, one thing I forgot to do is, because we know the answers, and so sometimes I forget to ask the question. Can you tell the listeners the difference between what is short-term disability and what is long-term disability? It seems so simple, but it really is. It can be very complex at the same time.
It can be very complex because there's no federal or state law that governs what it is. So short-term disability can be 3 weeks, 3 months, 6 months. I've seen it a year at bigger corporations. And long-term disability, I tell people, is anything that's a multitude of years. Okay?
Makes sense.
So when you get a policy, short-term or long-term policy through work, and if anybody has it that's listening out there and they don't have a copy of their policy,
get it now, right?
Get it now. You can ask HR. Do not call the insurance company. It's not their obligation to give it to you. It's your boss's. So call HR, get a copy, and have it. That's the rule book. And everybody's, it's like what you get in car insurance, right? When they go, oh, don't worry, Matt.
I'm fully covered.
I have full coverage.
Yeah.
No, you don't.
Right.
So there is no full coverage in this stuff. So get it. Because if you have short-term disability right now and long-term disability and you don't know how long they pay for, why are you spending the money on them?
True.
Because you don't know if you're paying for 3 months and a year, or you're paying for a year and then until you're 67. You don't know what you're paying for. And how can you value your money or your return on investment, the ROI, as people say?
Right.
So short-term is usually for a set term of time. Again, on the outside, it's about a year. Usually it's 3 to 6 months. And then long-term kicks in after that. And it's not like Social Security. In order to get Social Security, you have to be disabled or will be disabled for a year. You can be on long-term disability for 2 months if you had knee surgery and it's, it doesn't, you're not going back to work at 6 months. It really takes 9 months. They can just pay 3 months of insurance.
Right. And we see that a lot in our
Right.
Social Security disability. We have people call and say that they're out because of a surgery or because of a condition that's going to get better. Can I have temporary Social Security disability? And so we always have to tell them no.
Yeah.
We ask them if they have short-term or long-term disability, and then we send them on over to you guys.
I appreciate it.
Because Social Security disability is it's not a temporary thing. It's getting your Social Security benefits early because
Right.
of a disability.
Right. Well, and as you know, the Social Security disability averages about $500 to $700 less than what their full retirement is at the time that they get it.
Right.
So it is still a little bit of a haircut, but if you truly can't work and you don't have these other policies, I mean, you've paid into it. And I want to say right now, guys, Social Security disability, SSDI, Title II, is not a entitlement. It's taken out of your check
Right.
every week. So
Right.
you're paying for it.
Now we have that discussion with our clients all the time. Oh, I feel bad about having to file for
You're
Social
paying
Security.
for it.
You paid for it, exactly.
Unwillingly paid for it.
and a lot of times they say, "Oh, we have." They don't even understand.
They don't understand
that.
So they just think it's for retirement.
Right.
But Social Security, retirement, disability, and widow benefits are all under the same act and are drawn from the same pot.
Yeah, taken out of your paycheck the same way.
Same way.
Yeah. Well, I know that there's been when we're talking about short-term and long-term disability, can a person have one but not the other? And should they?
Well, the answer to that is no. They should have both. Okay. Now, sometimes it comes down to finances. So I tell people, well, don't go with the cheaper one because the cheaper one is always short-term disability. You want long-term disability instead of short-term disability because you can go maybe 3-6 months without a paycheck. Can you go 15, 20 years?
Right.
Okay. So you can have both and you should have both. I've seen a lot of times where people only have long-term disability, but don't have short-term, or have short-term and don't have long-term. And I think the one that's most heartbreaking is the one that has that really serious accident and they only have short-term disability. And they call me up upset that in a month their benefits are over and what can they do?
Right. And so, of course, they can apply for Social Security disability if they're going to be out for 12 months or longer. But that's just applying for Social Security disability. The Social Security process can be 18 months to 2 years. And how are they going to survive during that time? And that's why long-term disability comes in and so to be so helpful.
Right. And it's surprising, though, and I'm going to tell people out there, when I say that you get what you pay for, I am not telling you not to get long-term disability through your employer. Okay. I'm saying if you have the option, you get the long-term disability through your employer and you pay for a private policy. You do both because, quite frankly, the short-term disability and long-term disability through your employer, it's kind of like the health insurance. It's $10 a month, $12 a month. Maybe some employers it's more expensive given on how they contribute. But you need to look at that as if you try to get that same policy in a private policy, it's going to be $400 or $500 a month. So you want to make a decision on your benefits, not based on, well, short-term is cheaper than long-term, so I'm going to get short-term. Right. If you have to pick between the two, you pick long-term.
Right. That makes sense. Well, we're about to take our first break. Again, you're listening to FLA Law on the radio. This is a live legal call-in talk show. If you have questions about Social Security disability, long-term disability, short-term disability, or any other questions, Bill and I think we can tackle just about any question. So give us a call on the other side of the break. Thank you.
This is the Tan Talk Radio Network.
For the medical bills, what about my lost wages, and more? The personal injury law firm of Perenich, Caulfield, Avril Noyes has been answering these questions for their clients for nearly 70 years. Since 1955, they've been a voice of the injured in the legal system. As one of the longest established law firms in Tampa Bay, Perenich, Caulfield, Avril Noyes is here to answer your questions. Listen to their live call-in radio show on this channel every Tuesday evening from 5 to 6 p.m. or call them at 727-796-8282 or visit them at voiceoftheinjured.com. Offices Clearwater, non-attorney spokesperson.
This is the Tan Talk Radio Network.
We are back. Hi, I'm Matthew Noyes. I'm one of the partners at the law firm of Perenich, Caulfield, Avril Noyes, the proud sponsors and providers of FLA Law on the radio. We are here every Tuesday from 5 until 6 as a service to our community to be available to answer questions that you may have, questions that you don't have to pay a lawyer to get answered. So we are here for about another 25 minutes. I have a friend and a colleague here, Bill Demis. I've always pronounced your name wrong. You corrected me last time, but for 20 years I pronounced it wrong. But Bill is here to answer questions that you have regarding disability policies, whether it's short-term disability, long-term disability, accident, dismemberment policies, and ERISA policies and such like that. So the number again is 727-441-3000. But Bill, before we take a call, why don't we kind of walk our listeners through the process? You're an employee. You either get hurt or you're diagnosed with a condition that's going to keep you out of work for a period of time. What's the steps that employee should take?
Oh, that's a great question, Matt. I do think that there is a right way and a wrong way to do this. Some people disagree, but I'm going to tell you, there's a right way and the wrong way. The right way is as soon as you know you have a condition that's going to keep you out of work, the first thing you do is you talk to your employer about it. Now, people say, I can't talk to my employer. If I tell them I have a disability, they're going to fire me or get another job. And folks, they can't do that.
Right.
Well, they can, but it's illegal.
Right.
So but most people that have long or short-term disability through the work also work for companies that qualify for Family Medical Leave Act, FMLA. So if you know you have a condition that's going to take you out, maybe you have a knee surgery, you have something that's going to take you out for 3 months or whatever, 6 months or maybe longer, the first thing you do is you call HR and you say, I have this condition. I want to apply for Family Medical Leave Act and I want to apply for short-term disability. You do it in a call and then you do it in an email.
Document.
So you can document that you told your employer about it. And then what happens is you're going to be doing both. Now, yes, people, you can have FMLA and short-term disability because Family Medical Leave Act is unpaid.
That's what I was going to raise, is because a lot of people think that they're on FMLA, so that means they get paid.
No.
And it's not. All that does is hold your job available for you.
And what you also run into on the disability side for your Social Security, somebody says, yeah, I'll get it. I was approved for Family Medical Leave Act, so they know I'm disabled. I said, well, no, not really, because I can take Family Medical Leave Act because my wife is sick. That doesn't mean I'm disabled.
Right.
Or, one of my kids has a baby. I can take FMLA for that.
Right.
So it doesn't mean that you're disabled. But what it does is it protects your job while you're fighting with, hopefully not fighting with, but working through the short-term disability process, because that is not instantaneous. They want more information than FMLA. FMLA is usually 1 or 2 forms, and the doctor just can say, yeah, they have a condition that meets the criteria, and they don't have to do documentation or anything. They just have to say it meets it. Short-term disability, you have to provide your medical records. So that's what you do. But there's if you know, unless it's a sudden accident, if you know you're going to have to do it, you prepare, meaning you get your medical records from your doctor. You get all the information. You tell your doctor, okay, I'm having surgery. I'm going to go for, short-term disability. Are you going to would you be willing to fill out forms for me? Because if he says, I don't fill out disability forms, but he's going to perform your knee surgery and he's the only person or she's the only person that can certify you're out, I don't even know how you get FMLA. So you need to prepare yourself for that information.
Right. And so if they won't fill out the forms, then you really kind of have to wait for the medical records to be generated, which delays the process a little more.
Right. Now, again, if you have, most surgeons will fill out forms. Okay. Right. And maybe surgery is a bad, but because you have specialists that treat people that have really disabling conditions. I'll say, I don't fill out forms.
Yeah.
So when the clients call me and say they won't fill out forms, you probably say the same thing. They say, well, we either run a risk of not having your forms filled out and denied, or you find a new specialist.
Right. Exactly.
Because Social Security doesn't care that your doctor doesn't fill out forms.
Right.
The Hartford doesn't care that in fact, they want your doctors not to fill out forms because that's a reason for them to deny your case.
Right.
So once you're on short-term disability, the fight is not over. Okay, because if you have long-term disability, short-term disability and long-term disability most likely have 2 different definitions of disability, even if they're in the same company.
Oh, wow. Okay.
And how the federal courts say you look at a short-term and long-term disability company are as 2 separate companies, meaning Hartford A and Hartford B.
Okay.
So whatever you sent the short-term disability is not known to the long term. So where a lot of people get mistakes is that, the long-term disability adjuster will say, send me your medical records, fill out this forms. And what do they say? I've done that already.
Right.
You have that.
I'm not going to do that again.
I'm not going to do that again. Well, then you're going to lose your case.
Right.
Just like if Social Security sends them that disability report appeal for the 15th time,
right,
and your client refuses to fill it out, what do you say? Well, they're going to deny your claim.
Right. Exactly.
You have to fill out the forms.
Jump through the hoops and hurdles.
Right. So that's what people have to realize is that you also need to start preparing for your long-term disability case about a month before the transition. So get your medical records. Make sure your symptom journal is up to date. Make sure that you're taking pictures of your extremities if they're swollen or red or whatever. Make sure you have all your ducks in a row. And always, always, always remember, and this is not a knock on the people that work at these companies, but as a general rule, you have to remember Social Security is not your friend and not your advocate. An insurance company is not your friend and not your advocate.
Every penny they pay out in benefits is a penny out of their profits.
Right. Well, and when people turn around to me, Matt, and say, I can't believe my insurance company did that. And I'm like, well, that's like you walking into McDonald's and being upset that they're trying to sell you a hamburger. That's their business model.
Right. Exactly true.
That's their business model. So how do you expect them to act differently? So you prepare. You don't trust them. You get your medical records, you get your information, and you send it in certified mail so they can't say that they don't have it.
I think that's good. Mm-hmm. And so you go through the short-term disability, and let's say that's a 6-month policy benefit period. Then you have to apply for the long-term disability after it runs out, or you can do it. Can you do it near the end of short-term disability?
I recommend that people about a month out start asking their short-term disability adjuster for the long-term disability application. And what they'll tell you is, no. It transitions. Funny. In all my years of experience, the only thing that transitions over to the long-term disability from the short-term disability are all your negative medical records. All the good ones never make it into the claim file.
Isn't that amazing?
I don't know. That darn computer system is messing up. But so you ask them for the application and you push them, because what's going to happen is they may do the transition, and then all of a sudden you're supposed to be getting paid, and the short-term disability company says, well, that's the long-term, and then the long-term disability company sends you 6 forms, and we need all these medical records, and then we're not going to pay you until you provide this. Right. And you've seen that with Social Security too.
Yes.
And then it takes you 2 months, and you're not getting paid for 2 months. So if you start early and understand that they're going to want your medical records, they're updated, not the ones you sent in, and they're going to want your doctors to fill out forms, you have to act timely on all that stuff, or they drag their feet.
And does the carrier have a right to send your client to one of their doctors?
Yeah, the clients, they have a right to send you to what's called, they call it an independent medical examination, an IME. Yeah. There is nothing independent about a doctor they're paying about $3,000 or $4,000 to for an opinion.
Right.
Nothing.
That happens in the auto cases all the time too. They call them IMEs. They're not IMEs. They're CMEs. They're compulsory medical examinations. You gotta go.
And yes, they can send it out. But you also have to remember is that in the state of Florida, unless it's a mental health evaluation, neuropsychological testing, or a psychiatrist, that the person that's being forced to go can have a person there taking notes, and they can record it. They can do all those things. As you know, with your people think it's only for personal injury, but if the insurance company is sending my person for a CME that's not mental health related, I tell the carrier, nope, I'm sending a videographer. And they go, well, ERISA doesn't allow that. Yeah, but the Florida insurance law does, and the savings clause doesn't preempt it. So here's a Supreme Court case, and there's going to be a videographer there.
And the adjuster's like,
and the adjuster's like, well, ERISA does. I'm like, you can say that time and time again, but read the Constitution and read these Supreme Court cases. I can have it. Okay. And that is really telling people think they have to go in there alone. Listen, if they're sending you to one and you, of course, you don't want to hire a videographer, and is the doctor really going to allow your wife, fiance, husband, friend to sit there with the video camera? Probably not.
Right.
But you need to assert your right to have somebody in there with you to take notes, because when the doctor says in his report that he spent an hour and a half with you and you go, it was 10 minutes.
I sat in the room for an hour and a half, but the doctor was only there for 10 minutes.
How do you prove that? You prove that with testimony of somebody say, this is when the click again, the camera guys, this is when the doctor came in, took a picture, this is when the doctor left.
Right.
We were only there for 10 minutes.
Right.
So those are the real important things.
What about, we've been talking about Social Security and how it relates to the long-term disability and the private policies. But why don't we explain to our listeners a little bit more is, how they interact with each other, but they're two totally separate entities.
Right.
Can the two ever meet, I guess?
Well, you can have both.
Right.
Okay. But you have to remember the rule is that a insurance company, so not the government, an insurance company is going to deduct what you get from Social Security dollar for dollar. So quick math, you get $3,000 from your insurance company, your long-term disability policy, and Social Security pays you $2,000. Your insurance company is only going to pay you $1,000. So you get $3,000 total. Because if you look at long-term disability policies nowadays, they're really written like gap insurance policies. They only guarantee that they're going to pay you 60% of your wages after all other benefits are paid to you for your disability.
Sure.
So if you come up short of that 60%, they're going to kick that money in.
Right.
But now short-term is usually not affected because it's usually 6 months or less, and Social Security doesn't pay for the first 6 months, 5 full months, which is usually 6. Now, the thing that people really have to remember is they don't have to listen to each other. I can take a Social Security judge's award and walk into a federal judge and say, look, the government of the United States says they're disabled. And the judge goes, oh, that's nice. But do they meet the terms of this policy?
Right.
Okay. And Matt, you've seen it with your disabled veterans, which is a crime what Social Security does to them, where they're 100% disabled. And the judge goes, you go, Judge, look, this is the rating decisions. This is their permanent and total disability. This is their, individual uninsurability rating. They're, and what does a judge ask you? How much are they getting total? Right.
Right.
Because, they're going to get a lot of money. Or they turn around and they say, yeah, but how does that affect me? Because, surprise, surprise, the U.S. government doesn't even have to listen to the U.S. government when it comes to disability.
That's right. It drives me crazy, but that happens all the time.
Right. And your clients look at you like, why not? And you're like, well, it's the law.
Right.
So a lot of times people come to me and say, slam dunk case, I got Social Security disability. And you're like, no, they don't have to listen to it. Just like the Social Security judge doesn't have to listen to the insurance company. They have to make their own decision as decision makers and fiduciaries.
And we see a lot of times when our clients are coming who are on long-term disability, they come to us and say, oh, well, my long-term disability carrier wants me to go to this company for me to try to get Social Security disability. And it's a company that's doesn't even have to be lawyers, that the long-term disability carrier is trying to get them to go to.
Right. I'll address that really, really quickly. First of all, there's policies, most policies write that you have to apply for most long-term disability policies. We're saying so many acronyms here. It's kind of like we're talking about work comp again. There are some policies, literally most of them, make you apply for Social Security disability because they get the offset.
Right.
Okay. But they don't have to follow it. They just want you to apply. So anyways, so what they tell you is that you have to apply. And yes, folks, you have to apply. If you don't apply they're going to estimate what you're going to get from Social Security and deduct it anyways.
Okay.
And the federal courts have said that's fine. So you have to apply, okay? But you don't have to use the person that they send you to.
Right.
You can call Matt, he can represent you, and he'll do a better job. And don't be sucked in by you should use XYZ Corporation that just use non-attorney reps, because we pay for it. Well, here's the skinny on that. They're paying for your attorney anyways.
Right.
Because they're only allowed to recoup from you the amount that they actually get in their pocket and back benefits. So if somebody hires you and they get $30,000 in back benefits, and your fee comes out of that, let's say for a round number, it's $5,000. Your client's going to get $25,000.
Right.
New York Life or Hartford can only get back from them $25,000.
So it's the same. Right.
It's the same.
Right.
But these companies that work with the insurance companies, a lot of them have you sign releases that allow your representative to talk to the adjuster of the insurance company without you on the phone.
That I've seen that, and it just drives me crazy.
Right. And you see your representative being able to directly write notes into the insurance company's claim system, talking about how they're going to get you to pay back your overpayment. And the other thing is, and Matt and I have a lot of cases before, is that I will alert Matt that, listen, yeah, you have Joe Blow, but the insurance policy has a mental health exception. So don't focus on his anxiety and his depression, his PTSD. Focus on the fact that he has six herniations in his back, and get the judge to approve that. Based on that. Because a lot of these companies go for the low-hanging fruit, which is the mental disability.
Right.
And also, it just happens to be an exclusion.
Yeah, look at that.
Right. And long-term disability insurance carriers don't need to listen to Social Security judges until they want to.
Right.
When the Social Security judge says, I think it's a mental disability. We don't have to pay past 2 years.
Yeah.
So you want somebody that's an advocate on your side and that is willing to work with your long-term disability attorney like Matt and I do, because we share medical records. I will send him the policy and say, listen, this is what you have to avoid. He will double check with me. It's so important that if you have multiple attorneys, that they are working together to maximize your recovery.
So true. And if one's picked by the insurance company,
it's not going to happen.
It's not going to happen.
It's not going to happen.
We have a little bit more time, but I don't want to forget to talk about something that you and I encountered just this week.
Okay.
And that's the pre-existing condition.
Yeah, that's right.
In Social Security disability, pre-existing conditions really don't play a big role because we look at the person as a whole. But in long-term disability and short-term disability, that could have a big difference, right?
Absolutely. Most of these policies have a pre-existing condition clause, the long-term disability policies. And the reason they have these pre-existing clauses is because they don't want somebody to go to the doctor, find out they have cancer, go to work, buy the policy, and then after 2 months, start getting chemo. And then the company, the insurance company, after 2 premium payments, has to pay them for the rest of their life.
Right.
Okay. Some people say that's unfair. The federal judges have said, no, it's fair as long as the pre-existing period is reasonable. So what that means is most policies say, hey, listen, from the date that the policy is enacted, let's say that's January 1st, your coverage starts. It's either 1 year, sometimes you see 2 years. If you file for disability in that 1 or 2 years, we're going to look back 3 to 6 months before your policy is enacted, meaning they'll go back to June of the year before it started, or September, and they'll look at it and they'll say, were you treating for any of those conditions? So, were you diagnosed with cancer in those 6 months before you went on the policy? Okay. And what people fail to understand is it doesn't matter if the condition got, quote, worse. If you were taking medications, if you were seeing the doctor, and there's no huge intervening accident. What I tell people all the time, if somebody has a sore back and has been going to, massage therapy and the physical therapist because, they tweak their back in the backyard, and then they get the policy and 4 months later they have a traumatic, car accident that literally breaks their back, the pre-existing condition is not going to kick in there. But let's say that you're on statins and you're on cholesterol medicine and you go to your cardiologist every year, and then within the pre-existing period you have a heart attack. you're not going to be covered for that.
Right.
Because the judge is going to say, well, there's no intervening accident that makes you have a heart attack. Or, the sad cases are the mental disability cases where somebody, is on, mental health, working, but on mental health medications and seeing their therapist every month. And then all of a sudden they have a decomposition, they have an episode that's not triggered by any intervening accident.
Right.
Not a death in the family, not a car accident, not an attack. You lose those cases.
Right.
Because they say, yes, you were treating for this, and now you're disabled from it, and nothing intervening happened. So what I tell people is the earlier you get these policies, the better. Don't wait till you have a condition to try to buy insurance, because that's like buying car insurance after you wreck your car.
Yeah.
It's not going to work.
Right.
You get it early.
No, I think that's so important. It's why it's so important to get that policy too.
Right.
Once you have it. So you have
the rule book.
Yeah, the rule book for the board game, so to speak.
Right.
Well, we have a few more minutes. Bill, thank you so much for taking time out to educate our clients and educate me as well. So thank you very much. But if people have questions regarding disability policies and such, how can they reach out to you?
Sure. I'm at the firm of Herman and Wells in Pinellas Park. Our number is 727-821-3195, 727-821-3195. And you can find us online at hermanwells.com. And my information is there. You can call in and talk to me. I'll be happy to have a discussion with you. If people have questions about their long-term disability policy, they can call up and ask me about them. Sometimes people, as you know, they want a lot of questions answered, and we may have to charge for that. But normally what it is, if they have a quick question or whatever, I tell people to call me in the beginning, and I can give them roadmaps of how to do it and which way they can do it with me, which way they can do it without, and then they can make the decision on their own.
And many times, and we do that in Social Security as well, you give them that roadmap and they'll try, but they come back because you were genuine enough and you gave your time and gave your education, and they trust you.
Right. I mean, it's funny, and you'll understand the irony of this. And when I say it to people on the phone, they kind of get put back at first. But I say, hey, okay, I'm not gonna be able to help you, but I hope I never talk to you again. And they go, what? I said, I hope I never talk to you again, because that means that either Social Security or the insurance company did what they're supposed to.
I do that to my clients. I hope I never have to represent you again.
Right.
I wasn't that bad, was I? But no. But again, Bill, thank you very much. Why don't you give your telephone number one more time for our listeners?
Sure. My name is Bill Demas, and I'm at Herman and Wells, and the number is 727-821-3195.
And I'm Matthew Noyes, and one of the partners at Perenich, Caulfield, Avril Noyes, and we will be back next Tuesday for FLA Law on the radio. We appreciate you taking the time this week to listen to us. And in the meantime, drive safely and watch out for those who don't. Take care.